The court is now in session. We call on CTA case number 9519, a petition for review filed by petitioner, Commissioner of Internal Revenue, on December 7, 2020, assailing the decision dated June 17, 2020, and the resolution dated October 30, 2020, entitled Clarkwater Corporation versus Commissioner of Internal Revenue.
Now, I will be presenting the facts that were submitted by both parties. On August 3, 2015, a letter of authority number 218-2015 0000162 or ELA 2011-00064214 was received by Clarkwater Corporation from BIR RDO number 21A North Pampanga, indicating the authority of Revenue Officer Amor Canlas and Group Supervisor Jose Gil Reyes to probe the book of accounts and other related accounting records for all internal revenue taxes of Clarkwater Corporation covering the period of January 1, 2014 to December 31, 2014. On July 7, 2016, Clarkwater Corporation received a copy of Preliminary Assessment Notice or PAN stipulating a comprehensive amount due of 3,827,590 pesos point 31 cents for the division income tax, VAT, and expanded withholding tax, inclusive of interest, penalties, and surcharge for calendar year 2014. On July 27, 2016, Clarkwater Corporation disputed the findings regarding VAT deficiency by filing its protest letter to the Preliminary Assessment Notice. On August 15, 2016, the receipt of the proof of payment on the deficiency amounting to 299,905 pesos point 90 cents for income tax and 40,031 pesos point 33 cents for expanded withholding tax was acknowledged by Attorney Jetro M. Sabariaga. On October 5, 2016, the formal letter of demand or FLD and final assessment notice or FAN dated September 19, 2016 of the Commissioner of Internal Revenue was received by Clarkwater Corporation, where the deficiency VAT amounting to 4,406,648.49 cents for calendar year 2014 was specified. On November 4, 2016, Clarkwater Corporation filed its protest letter to the formal letter of demand and final assessment notice. On December 16, 2016, the final decision on disputed assessment, dated December 6, 2016 of the Commissioner of Internal Revenue was received by Clarkwater Corporation, where it indicated its denial for the protest to the formal letter of demand and final assessment notice. On January 16, 2017, a petition for review was filed by Clarkwater Corporation. On April 7, 2017, the Commissioner of Internal Revenue filed an answer to the petition for review filed by Clarkwater Corporation on January 16, 2017. On April 21, 2017, an urgent motion to defer pre-trial conference was filed by Clarkwater Corporation. On April 24, 2017, a motion to reset pre-trial conference was filed by the Commissioner of Internal Revenue. May 25, 2017 is the new date for pre-trial conference. On October 12, 2017, Clarkwater Corporation filed its formal offer of evidence. On October 23, 2017, the Commissioner of Internal Revenue replied to the formal offer of evidence of Clarkwater Corporation. On February 15, 2018, the court admitted Clarkwater Corporation's exhibits through a resolution. On March 8, 2018, Clarkwater Corporation filed its motion for partial reconsideration. However, the Commissioner of Internal Revenue failed to comment on the said motion. On October 19, 2018, the Commissioner of Internal Revenue filed a formal offer of evidence. On November 14, 2018, Clarkwater Corporation filed its comment to the Commissioner of Internal Revenue's formal offer of evidence. On January 22, 2019, the court admitted all exhibits offered by the Commissioner of Internal Revenue. On July 8, 2020, the Commissioner of Internal Revenue moved for reconsideration after the court dismissed the petition for review, ruling that the subject tax assessment lacks the definite amount of tax liabilities for which Clarkwater Corporation is accountable. On October 30, 2020, The reconsideration filed the Commissioner of Internal Revenue was still denied through a resolution. On December 7, 2020, the Commissioner of Internal Revenue elevated the case to the Court en banc. On January 6, 2021, the Court en banc ordered Clark Water Corporation to file its comment to the petition. On January 25, 2021, Clark Water Corporation filed its comment to the petition. On February 4, 2021, the Court en banc referred to the case of the Philippine Mediation Center Court of Tax Appeals for mediation. Finally, on July 19, 2022, the mediator's report from Philippine Mediation Center Court of Tax Appeals was received by the court stating that the mediation was unsuccessful.
After hearing the facts, we can now proceed to the arguments of each party, where the Commissioner of Internal Revenue is the petitioner and Clark Water Corporation representative as the respondent.
Your Honor, Clark Water Corporation failed to raise the issue of the validity of the FLD. I was also denied procedural and substantive due process when the court in division ruled on this issue.
Your Honor, I would beg the court's indulgence for a moment, please. The Commissioner of Internal Revenue was not denied the process when the court in division ruled on the validity of the FLD, as it lacks an imperative for payment and a definite amount of tax liability being demanded to our corporation.
Your Honor, achieving an orderly disposition of cases under the RRCTA is not synonymous with violating litigants' rights. Also, the said FLD or FAN already set the deficiency VAT liability that is being demanded from CWC. The statement on the FLD or FAN was also clear that the basic deficiency VAT remains the same and only the interest adjusts if the tax liability is paid after October 31, 2016. So, CWC cannot argue that they have no knowledge of the tax deficiency, as they have clearly indicated the amount of their deficiency tax liability in their protest against PIR and their petition for review.
Your Honor, the petition for review should be denied due to lack of merit, as the same arguments were raised in the Commissioner's motion for reconsideration dated July 8, 2020, which the court in division discussed and passed upon in the resolution.
I suppose CWC had also misunderstood the extent of their privileges as a business operating in a Freeport enterprise, Your Honor, as they assumed that they can still be subjected to a 5% preferential tax for the services that they have generated in the customs territory if it did not exceed 30% of their income from all sources. Our assessment regarding their deficiency VAT was in fact based on Department of Finance Department Office number 3-08, where it was explicitly stated that the special 5% tax on gross income earned only applies on gross sales or revenues generated within the Freeport zone. With that being said, CWC's sales transaction outside the Clark Special Economic Zone for calendar year 2014 will be subjected to a 12% deficiency VAT since the cross-border doctrine is also in effect. I also believe that the interest and surcharge imposed to CWC is only proper pursuant to Section 248 and 249 of the tax code, as they have failed to pay the VAT due within the period prescribed by law.
Objection, Your Honor. The statement calls for legal conclusion. Assuming, for argument's sake, that the FLD is valid, the deficiency VAT should be cancelled because, as a duly registered Clark Special Economic Zone, our company's sales transactions within the customs territory are subject to a preferential rate of 5% tax on our gross income, in lieu of all national and local taxes under the Republic Act No. 7227, as amended, and are thus not subject to 12% VAT. So, what are the issues in this case? First, whether or not the Honorable Court in Division erred in granting a relief that was not prayed by the respondent. Second, whether or not the Honorable Court in Division erred in ruling that the assessment did not indicate a definite tax due nor a demand for the payment of tax. Third, whether or not the assessment for a deficiency value-added tax issued against the respondent has basis both in fact and in law. And fourth, whether or not the imposition of surcharge, interest, and compromised penalty against the respondent has basis both in fact and in law.
Now, therefore, I hereby present to you the Court's rulings. First, the Court in Division did not err in granting a relief that was not prayed for. Hence, it may rule on related issues even if not raised by the parties. The Court of Tax Appeal is given the authority to resolve related issues under Section 1, Rule 1424 of the Revised Rules of the Court of Tax Appeals, although not raised by any of the parties during the trial or in their respective pleadings. Section 1, Rule 14 of AM number 051107 CTA, or the Revised Rules of the Court of Tax Appeals reads, in deciding the case, the court may not limit itself to the issues stipulated by the parties, but may also rule upon related issues necessary to achieve an orderly disposition of the case. Therefore, CTA Division was within its authority to consider in its decision the question on the scope of authority of the revenue officers who were named in the letter of authority, even though the parties had not raised the same in their pleadings or memoranda. The CTA en banc was likewise correct in sustaining the CTA Division's view concerning such matter. Second, the Court in Division erred in ruling that the assessment did not indicate a definite amount of tax due and a demand for payment. The FLD and FAN contain a definite liability and due date. With the due date of October 31, 2016 stated explicitly in the FAN, together with the above computation of VAT liability up to the said due date, there is a definite amount of tax liability in this case. The statement in the FLD that the interest and total amount due will have to be adjusted if paid beyond October 31, 2016 does not make respondents' deficiency VAT liability indefinite to render the subject FLD or FAN void. The statement merely reminded respondent that the interest would have to be adjusted if the assessed VAT liability is paid after October 31, 2016. Undeniably, the interest due on the VAT assessment is subject to change, considering that the BIR could not foresee when the respondent would pay the deficiency taxes. Consequently, the total amount due will have to be adjusted. Thus, the subject assessment is valid because it contains a definite due date and a definite tax liability. Third, the assessment for deficiency VAT has basis both in fact and in law. Respondent is liable to pay VAT from its sales of services within the customs territory. In response to respondent's protest to the FLD, petitioner argues that Section 5 of the Department of Finance DO number 0308 provides that for purposes of implementing the special 5% tax on gross income earned, in lieu of national and local taxes granted to Ecozone enterprises and Freeport enterprises, shall refer to gross sales or gross revenue derived from business activities within the subject Ecozone or Freeport, net of sales discounts, sales returns, and allowances, minus the cost of sales or direct costs. Petitioner further argues that the Philippine VAT system adheres to the cross-border doctrine, according to which no VAT shall be imposed to form part of the cost of goods destined for consumption outside of the territorial border of the taxing authority. Hence, the actual export of goods and services from the Philippines to a foreign country must be free of VAT, while those destined for use or consumption within the Philippines shall be imposed with 12%. Respondent Clark Water Corporation's sale of services within the customs territory or outside the Clark Economic Zone or Freeport Zone area is not exempted from the payment of VAT. It is considered importation by the buyer, hence subject to 12% VAT. Lastly, the imposition of surcharge, interest, and compromise penalty against respondent has basis both in fact and in law. Respondent is ordered to pay petitioner the aggregate amount of 8,995,448 and 28 centavos, inclusive of the 25% surcharge, 20% deficiency interest, and 20% delinquency interest imposed under Sections 248A, Clause 3, 249B and C of the NIRC of 1997. Section 248A Clause 3 states, there shall be imposed, in addition to the tax required to be paid, a penalty equivalent to 25% of the amount due in the following cases. Under Clause 3, failure to pay the deficiency tax within the time prescribed for its payment in the notice of assessment. Further, Section 249B provides that any unpaid tax due shall be subject to 20% deficiency interest per annum, which shall be assessed and collected from the date prescribed for its payment until the full payment thereof. In addition, Section 249C provides that in case of failure to pay, the amount of the tax due on any return required to be filed, or the amount of tax due for which no return is required, or a deficiency tax or any surcharges or interest thereon on the due date appearing in the notice and demand of the Commissioner of Internal Revenue, there shall be assessed and collected a 20% delinquency interest per annum until the amount is fully paid.
Now we have heard and already have concluded CTA case number 9519, Commissioner of Internal Revenue versus Clark Water Corporation. Let us now move on the gist of the case by summarizing its implications through taxation concepts. The first section of CTA case number 9519 deals with how sales made inside of the customs territory are treated for income tax purposes. If the total income from all sources in the customs territory is greater than 30%, then the additional income is subject to the customs territory's income tax regulations. Export processing zones are effectively treated as foreign territory for tax purposes because they are to be managed as a separate customs territory from the Philippines. On the other hand, the VAT treatment stipulates that duties and taxes must be paid regarding transactions into and within the customs territory in any case, regardless of whether the income is sold within the Freeport Zone or within the customs territory. In this particular case, the respondent's place of business is situated in Clark Freeport Zone, Philippines, specifically at its location in Bicentennial Hills. Based on the aforementioned, the legislature intended for PEZA firms to benefit from tax incentives provided thereby specifically to transactions that take place inside the jurisdiction or to persons or establishments within the jurisdiction in RA 7227 as amended by RA 9400. As a result, the sales of services by Clark Water Corporation that were intended for consumption inside or outside of the customs territory should be regarded as importations by the buyer and exportations on the part of the respondent that are subject to 12% VAT, known as technical importations. Next implication would be the BIR's tax assessment process, which includes the issuance of letter of authority, preliminary assessment notice, and formal letter of demand or final assessment notice were also involved in this case. For a tax assessment to be valid, a letter of authority should be issued first, as it is a mandatory statutory requirement being highlighted in the Revenue Memorandum Circular number 07518. Meanwhile, on August 3, 2015, respondent received the letter of authority from BIR RDO number 21A North Pampanga, authorizing Revenue Officer Amor Canlas and Group Supervisor Jose Gil Reyes to examine respondents' books of accounts and other accounting records for all internal revenue taxes, including documentary stamp tax, other taxes for the period from January 1, 2014 to December 31, 2014. Therefore, the tax assessment was valid and there was no violation of the taxpayer's right to due process. The taxpayer must be given a notice of discrepancy if a revenue officer's examination determines that he is liable for deficiency taxes. However, in this case, issuance of ND was not mentioned. After the LOA, a copy of preliminary assessment notice dated July 7, 2016 was received by the respondent, assessing it of deficiency income tax, VAT, and expanded withholding tax for CY 2014 in the aggregate amount of 3,827,590.31 pesos inclusive of interest, penalties, and surcharge. Upon receipt of the PAN, the taxpayer has 15 days to provide its reply to it. According to the case, subsequently, the respondent received a copy of the PAN dated July 7, 2016. Clearly, there was no specific date of receipt mentioned, so it cannot be determined if such protest letter was filed within 15 days. In the protest letter, respondent disputed only the findings on deficiency VAT. If the taxpayer is still found to be liable to deficiency taxes, BIR may proceed in issuing a final assessment notice or formal letter of demand. From the receipt of that notice, the taxpayer has non-extendable 30-day period to submit its protest letter. Otherwise, the assessment shall become final and executory. In this case, the respondent receives the FLD on October 5, 2016 and filed its protest letter to the FLD on November 4, 2016, exactly 30 days from the receipt of FLD. Proceeding to the tax remedies. The Commissioner may first compromise the payment of any internal revenue tax when first a reasonable doubt as to the validity of the claim against the taxpayer exists or the financial position of the taxpayer demonstrates a clear inability to pay the tax. Second is to abate or cancel a tax liability when the tax or any portion thereof appears to be unjustly or excessively assessed or the administration and collection costs involved do not justify the collection of amount due. Third, remedy would be credit or refund taxes erroneously or illegally received or penalties imposed without authority, refund the value of internal revenue stamps when they are returned in good condition by the purchaser, and in his discretion redeem or change unused stamps that have been rendered unfit for the use and refund their value upon proof of destruction. With that, the petition is not meritorious although provided that the respondent is registered Clark Freeport Enterprise as evidenced by its certificate of registration and tax exemption Clark Business Registration number C2011-04828 issued by Clark Development Corporation. The petition is not subject to a reasonable doubt as to the validity of the claim against the taxpayer as the actual export of goods and services from the Philippines to a foreign country must be exempt from value-added tax, while those destined for use or consumption within the Philippines must be taxed at 12%. Consequently, the sale of services by Clark Water Corporation within the customs territory or outside the Clark Economic Zone or Freeport Zone is not exempt from the payment of VAT. The buyer is considered to have imported the item and a VAT of 12% applies.
In conclusion, the Philippine government depends primarily on taxes to finance national development initiatives. Therefore, being subjected to the collection of taxes stems from the privilege of an individual or non-individual like businesses to earn income. The case of Clark Water Corporation versus Commissioner of Internal Revenue depicts a variety of issues such as the validity of the FAN or FLD and income tax treatment, as well as the imposition of deficient value-added tax and surcharge, interest, and penalty against the respondent. Case at point, Clark Water Corporation, who is the respondent, was ordered by Commissioner of Internal Revenue, who is the petitioner, to pay the amount of 4,366,648 pesos and 49 cents of deficiency value-added tax for calendar year 2014, as well as 25% surcharge, 20% deficiency, and delinquency interest. Therefore, the court ruled in favor of the petitioner as it was well settled that export processing zones are to be treated as a separate customs territory from the rest of the Philippines. In connection, the income tax treatment of sales within customs territory, although not exceeding 30% of total income from all sources, must be excluded in the computation of the special 5% tax on GIE. With this principle, therefore, services of Clark Water Corporation conducted within the customs territory are considered as technical importations, thereby subjecting it to 12% VAT. Furthermore, the initial assessment of the petitioner for the deficiency VAT of Clark Water Corporation for calendar year 2014 amounted to 22,984,353 pesos and 84 cents, which represents only 6% of the respondents' total sales. Clark Water Corporation did not contest this assessment and even admitted the validation of ICPA, that the actual total sales within customs territory amounted to 33,912,547 pesos and 43 cents, or 8.86% of the respondents' total sales. Therefore, the court's judgment is appropriate and justified, given that the fundamental evidence lies on the respondent's admission that the total amount of sales within the customs territory was in fact higher than what was initially used by the petitioner as a basis for the computation of deficiency tax. If only Clark Water Corporation had been able to abide by the laws, rules, and regulations and instructions set forth for tax compliance, this might have been avoided. Furthermore, if Clark Water Corporation was uncertain about the proper treatment of their taxes outside the Clark Economic Zone or within customs territory, they could have availed tax advisory and compliance services, as businesses must place a higher emphasis on adherence with all tax regulations. Thus, it would have significantly made a difference if Clark Water Corporation considered consulting with tax professionals, as it would have saved them from the financial costs and the time of having to go through the lengthy process of court hearings, given that the underlying of the cause of the crux was the improper treatment of their taxes within and outside the economic zone, a matter which would have been avoided if Clark Water Corporation accordingly classified and computed its taxes based on the rules of the customs territory. Furthermore, to avoid prolonged trials, one of the benefits of availing compliance services is providing impartial attestation of financial and other relevant documents submitted as testimony in tax cases, disputes, or refund claims before the Court of Tax Appeals. This entails assessing the accuracy of the claims involved, the completeness and legality of the supporting documentation, and any other representations made by the taxpayer in accordance with the standards established by the relevant laws and regulations. With this case at hand, it must be a requisite for all taxpayers to thoroughly know the tax laws, rates, processes, requirements, and the remedies available to them when needed. Meanwhile, it is also the duty of the petitioner to execute its responsibilities thoroughly to avoid an incorrect conclusion that will cause an underrated or deficient tax collection. Hence, the petitioner still needs to be liable to an extent given that the initial assessment of the petitioner for the basis of deficiency tax of Clark Water Corporation for calendar year 2014 amounted to 22,984,353 pesos and 84 cents, which represents only 6% of the respondents' total sales. However, upon further validation of ICPA, the actual sales within customs territory amounted to 33,912,547 pesos point 43 cents, or 8.86% of the respondent sales. Hence, the basic deficiency tax was in fact 4,069,505 pesos point 69 cents, based on the actual total sales within customs territory of 33,912,547 pesos point 43 cents, VAT multiplied by a VAT rate of 12%. If not for the petition to review, the basic deficiency tax will be undervalued at only 2,758,122 pesos point 46 cents. This case can further undermine taxpayers' trust in BIR systems and processes given that it is possible that they can erroneously compute a taxpayer's tax due.